Hi guys, and welcome to another episode of Atty. Vlogger, Law for the Everyday Layman. Today we'll take up part 6 on the law of sales, and we'll be talking about double sales, okay? So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law, okay? Now we continue with the topic of double sales, no? If you will remember from my last video on the obligations of the seller or the vendor, it is one of his obligations to deliver the thing. Okay, and in line with that obligation to deliver the thing, he must deliver it to the person to whom he has sold the thing. Okay, so the rules on double sale will apply to a situation where the same thing is sold to different buyers. Okay, whether it be to 2 or even more buyers, no, in a line of succession. Okay, so the requisites for the rules on double sales to apply under Article 1544 of the Civil Code, no, are as follows. Okay, first, both transactions or all the subsequent transactions must be valid sales. Okay, so in other words, 1544 will not apply if the sale is void, or if the sale is a contract to sell, or if the sale is a conditional sale where the condition has not yet happened. Why? Because in these cases, the sale does not yet exist. Okay? Or in case of void sales, no, or sales with a void title, the sale does not exist at all. And the first requisite is that the transactions must constitute valid sales. Okay? Next requisite is that each sale must pertain to the same object. Okay, it must, if in case what is sold is a parcel of land, it must refer exactly to the same parcel of land, no, including the boundaries and the area. Okay, it cannot apply if different things are sold. Okay, next requisite, no, the buyer who is the buyers rather who are claiming ownership, they must have conflicting interests. Okay, 1544 will not apply if the interests of the buyers can be reconciled, no, such as when in the case that they are co-owners, no, and each owns a distinct share, no, even though it may not have been partitioned yet. Okay, so it will not apply in that case because the requisite is that the buyers claiming ownership must have conflicting interests. Okay, and the final requisite is that each of the buyers must have bought the object from the same seller. Okay, there will be no application if the seller is different. Okay, especially in the case where one of the sellers is not the actual owner, no? So each of the buyers must have bought from the same seller. Okay? Now, before I continue, I want to emphasize that registration of the land is different from registration of the sale. Okay? When we talk about registration of the land, we are talking in the current system, no, of the torrents system of registration. Before we had other systems of registration, no, under the Spanish time, no, etc. No, but what we follow today is the torrents system of registration. No, these are what we see in our parents or even your own titles. No, the OCT, Original Certificate of Title, or the TCT, the Transfer Certificate of Title. Now, what is the torrent system, no? The torrent system of registration is a system for registration of land under which, upon the landowner's application, the court may, after appropriate proceedings, direct the issuance of title. Okay? In other words, it's a judicial proceeding for the court to grant title upon the application of the landowner. The object of the torrent system is to establish and certify ownership of an absolute and indefeasible title to real property and to simplify its transfer. Okay? The purpose of the torrent system is to quiet title to the land and to put a stop forever to any question of legality of title, which cannot, after registration, be impugned or modified, altered, changed, etc. No? Except through a direct proceeding, and it cannot be a collateral proceeding to attack the validity of title. Okay? Now, when we talk about the title itself, no, the TCT or OCT or any other title, that is not a mode of acquiring ownership. That is mere evidence of ownership. Okay? Because if you will remember from my previous video, no, the modes of acquiring ownership are donation, succession, etc. Okay, occupation, like that, no? And the existence of a title is not a mode of acquiring ownership. It is evidence of ownership. Now, titles must be registered, no, under the torrent system. Okay, and as a general rule, the rules under 1544 on double sales apply to registered lands. Okay, however, in the books of Villanueva and Baviera, they have said that 1544 on double sales will also apply to unregistered lands. However, it must be unregistered all throughout. I'll talk about that more later on, don't worry. Okay, now, what I was talking about when I was discussing the torrents was registration of land. Okay, that's different, huh? Registration of the sale is different because the rules that I will be discussing later on involve registration of the sale, not registration of the land. Okay, because when we talk about registration of the sale, it involves actual recording in the registry of property in the various cities or provinces of the register of deeds, no? Okay, has to be actual recording. Now, the recording can either be actually in the books of the registry books, or it can be cancellation, annotation, even marginal notes can be accepted as registration. Okay, so we'll talk about that a bit more later on. I just want to emphasize that registration of land is different from registration of the sale, in which case you register your deed of absolute sale or whatever note or memorandum you have evidencing the sale. Okay? Okay, now let's talk about the rules. Okay, first, let's talk about the rules on movable property or personal property like watches, cars, etc. Okay, now in case of movable property that is sold to two or more different persons, the person who has the better right is the first to take possession of the thing in good faith. Okay, first to take possession in good faith. That's all you need to remember in movables. Now let's talk about immovables or real property, no? When we talk about real property, in case it is sold to two or more different persons, no? The first rule that we follow is that the first to register the sale in good faith has the better right. Okay? First to register the sale, not to register the land, not to register the sale. Okay? So the rule is the first buyer is always in good faith. Okay? He cannot be defeated in his rights by the subsequent knowledge of a second sale. Why? Because he's in good faith from the start. Okay? The only way that the first buyer can be defeated is if the second buyer will register his sale in good faith. Okay? So, when we say that he is in good faith, he should have no notice that any other person has a right or interest to the property, and he must pay full and fair price of the property at the time of the sale or before he has notice of the other's claim or interest over the property. Okay? So, again, first buyer is always in good faith. Okay? Even if he later on learns that there is a second buyer, his good faith cannot be defeated. Okay? The only time again that he will be defeated is if the second buyer registers the sale first in good faith. Okay? And again, registration requires actual recording either in the registry books or by cancellation, annotation, or marginal notes, as long as it is done before the registrar of property of the registry of deeds. Okay? However, what is not included in registration is declaration of the property for tax purposes. That's not included in registration under 1544. Okay? So the general rule, in case a person sees a title, no, a transfer certificate of title, he has the right to rely on the face of the title. So all he has to do is look at the title, look at the meets and bounds, check the memorandum of encumbrances if there are any liens or mortgages, etc., or any adverse claims, no? And he has the right to rely on that title alone, no? The exception would be in two forms, no? First, if there are facts which are present which create a duty to inquire further. Again, as a general rule, you do not have to inquire behind the title. Oh, is there a problem? Oh, are there other people claiming this? You don't have to ask. You can just rely on the title. But if there are facts which exist that create a duty on your part to inquire more, to investigate further, then you should investigate further. Okay? What are some examples? What if the property you're gonna buy, there are other occupants? Or someone else, not the seller, is occupying the property. There is another possessor, no? And what if there is an annotation of lis pendens, meaning that the property is currently under litigation? Those are facts which bring the duty upon you to inquire further and investigate. There must be something wrong in this title, okay? The second exception is banks and persons who are in the business of real estate. They cannot merely rely on the certificate of title. They really have to investigate, because for banks, their business is imbued with public interest and they have a higher degree of diligence, while persons engaged in real estate, by the nature of their business, should actually conduct investigations, okay? In order for their clients not to be prejudiced, okay? So again, the first rule in case of double sale of an immovable is that the first to register the sale in good faith has a better right to the property. Second rule, if there is no inscription or no one was able to register the sale, then it is the first possessor in good faith who will be entitled to the property, okay? When we talk about the first possessor, this can involve either material or symbolic delivery. If you remember my last video, there are different modes of symbolic delivery. We have traditio longa manu, brevi manu, constitutum possessorium, no? And this includes execution of a public instrument. If the parties merely wrote their contract or even typed their contract but did not have it notarized, then that is a private instrument. But when they have that private instrument notarized, it's now a public instrument or public document, because notarization makes a private document into a public document, okay? And execution of a public document is a mode of delivery or tradition, no? Symbolic delivery, okay? Also, in this case, the buyer must not be aware of any flaw in the title, because again, first possessor in good faith, okay? So, now, what if there is no registration? What if there is no one who first took possession in good faith? Then the final rule under 1544 is that the person who presents the oldest title in good faith will now be entitled to the property, okay? So what do we mean by oldest title? Okay, if you remember from my very first video, sale is title and not a mode, okay? So all we are talking about is oldest title, no? So any document which can show the acquisition of the land in good faith, like a deed of absolute sale, memorandum of agreement, receipt, no? These documents suffice, okay? But okay, this will not apply to a public document, because again, when we talk about a public document, that goes into the second rule earlier, in which case the first possessor in good faith will be entitled to the property, because remember, execution of a public instrument is equivalent to delivery because it is symbolic delivery, okay? So in case these rules do not apply, what rule do we apply then, no? We will apply the Latin rule primus tempore potior jure, no? Primus tempore potior jure, meaning first in time, better in right, or first in time, preferred in right, no? Okay, the first in time is better entitled to that right. Okay? So what situations will this first in time, better in right rule govern, no? Or in other words, when will 1544 on double sales not apply, no? These are the cases where 1544 will not apply. First, if not all of the elements or requisites for the application of 1544 are present, no? What are these requisites again? First, the transactions must be valid sales. They must pertain to the same object. The buyers claiming ownership must have conflicting interests, and each of the buyers must have bought from the same seller. If one of those four is absent, do not apply 1544. You apply primus tempore potior jure, first in time, better in right. Second example, when 1544 will not apply, no? When two of the contracts of sale are made by two different people and one of them is not the owner. In that case, you will just follow who is the owner, no? Because someone who sells who is not the owner cannot transfer any right. He's not the owner. He has nothing to pass. Okay? So definitely, 1544 will not apply. And finally, in the case where the first sale is over land which is not yet registered, and the second sale is over land which is already registered, pertaining to the same land. All it means is that this land was sold, it was not yet registered or even undergoing the process of registration. But when it was sold now to the second person, it was already registered. So in that case, 1544 does not apply. Okay? Again, in case the land remains unregistered all throughout the sales to the second person, the third, fourth, whoever, no? Then 1544 may apply. Okay? This is following Villanueva and Baviera, no? Okay, so let's give some examples, no? So let's say A has a parcel of land and he registers the land for the first time because it is previously unregistered land. While the registration proceedings are pending, meaning the land is not yet registered, A sells the land to B, okay? B immediately takes possession in good faith since he's the first buyer, no? But he fails to register the sale, okay? 1 month later, the OCT or original certificate of title is issued by the Register of Deeds to B, okay? But sometime later, because of a previous debt by A from C, no? He loses a case. And by virtue of the final judgment in that case, there is an execution sale or public auction over the land supposedly belonging to A, which is sold to satisfy the debt of A to C. Okay? At the public auction, C is the highest bidder and acquires the land. C now has that certificate of sale of the public auction registered. Okay? And after registration of that certificate of sale, he now sells it to D. Okay? Now, between B, who was the buyer who took possession but failed to register the sale, and D, who purchased the land from C, who was able to register the certificate of sale, who has the better right? B has the better right. Does Article 1544 on double sales apply? No. Why? Because the land was previously unregistered, then later on, in the second sale, it was already registered land. Okay? Now, this 1544 does not apply because the subject matter itself, the object, the land, it must be the same, possess the same nature all throughout the first, second, or subsequent sales. Okay? Since the characteristic of the land was different in the first and different in the second and the subsequent sale, then the 1544 does not apply. You have to remember that the law requires that any instrument which establishes, transfers, amends, modifies, or extinguishes rights over real property has to be registered in order to bind third persons. Okay? And the law says that this is without prejudice to a third person with a better right. Now, if you ask, doesn't C have a better right because he registered the certificate of sale? The answer is no. Why? Because in an execution sale, the person who purchases the property at such sale only steps into the shoes of the judgment debtor. In other words, who was the buyer in the execution sale? It was C. And C only acquired the rights of the judgment debtor, who was A. At that time when C was able to acquire the property, A was no longer the owner of the property because he had already previously sold it to B. Okay? Since C acquired nothing, he could also pass nothing to D, and therefore D has no right or title to the property at all. Between B and D, B has the better right. Okay? In other words, again, at the time of the execution sale, the mere registration by C of the certificate of sale did not give him any right, because he could not have gotten any rights from A, because A was no longer the owner at the time of the public sale. So here we have applied the first in time, better in right rule. B was the first in time, and therefore he has the better right to the property. Okay, and the certificate of the registration of the certificate of the public sale did nothing because C was not able to acquire anything from A in this case. Okay, this is the case of the Gupan versus Macam. Now let's give another example. No, same facts, but what if both sales were made over registered land? Meaning, first sale, registered land. Second sale to a different person, registered land. Then in this case, instead of B having the better right, it will now be D who has the better right. Why? Because in this case, 1544 now applies because the land is registered all throughout. Okay? Since C was able to register the certificate of sale where B did not, registration of the sale is better than the first possessor in good faith. Okay? Remember, the only thing that B has in his favor was that he immediately took possession in good faith. But C has a better right because he registered the certificate of public sale before he transferred it to D. So that act of C of acquiring a better right transferred to D, and D now therefore has a better right than B. Okay? Let's give a third example. What if through a private instrument, meaning it's not notarized, no, A sold land to B, but before B could fully pay the price, A also sold the same land to C through a public instrument. Okay, meaning it's notarized. Okay, C also took possession of the property. However, B learned of the sale to C, no? B learned of the sale to C, and he registered his adverse claim by going to the Register of Property and asking the Register of Deeds to annotate his adverse claim, okay? After the annotation of the adverse claim, C now went to the Register of Deeds and asked for registration of his deed of sale, and the TCT or Transfer Certificate of Title was now issued and given to C. Okay? And the Transfer Certificate of Title contained the annotation of the adverse claim of B. So who between B and C has the better right? Okay? B has the better right. Why? Because Article 1544 applies. B was a purchaser in good faith from the very beginning. Okay? First, he could not have been aware of any sale to C at the time that he bought the property because the sale to C did not exist yet. And that good faith subsisted, no? It continued all the way until he registered his adverse claim with the Registrar of Property. Okay? With the Registry of Property, no? So this effect of registering his adverse claim by making an annotation in the title had the effect of registration. Okay, remember, registration must be actual. It can be in the books. It can be a mere cancellation, mere annotation. So in this case, since he annotated his adverse claim, that is already equivalent to registration, and he now has a better right, no? And after all, this is the only thing that B could have done, because B does not have a public instrument. Remember, it was only a private instrument. Okay? So he cannot have the private instrument registered. So what B can now do is go to A and ask and compel A to observe the required form. No, if you remember my discussion in obligations and contracts, no, he can now compel A to observe the required form and to place the private instrument, to convert the private instrument into a public instrument through notarization. Okay. Let's give another example, the fourth one, no? Let's say X X sells registered land to Y on June 7, 2004. Okay? In the presence of Z. X sells to Y in the presence of Z. Okay? Y did not register the sale. Okay? However, on July 12 or more than a month later, X sold the land to Z. And Z registers the sale. Who has a better right? Is it Y or Z? Of course, it's Y, because even if Z was the first to register, he is the second purchaser, Z is in bad faith. Okay? In order for the second purchaser to overcome the preference of the first purchaser, he must register first and be in good faith. Since Z was present when X sold the land to Y, then he had knowledge of the first sale, so he is in bad faith. He's not in good faith. Okay? Let's give a fifth example, no? X sells a parcel of registered land to Y through a public instrument, okay? But X, the seller, remained in possession, okay? Subsequently, X sells the land to Z, who takes possession, okay? So Z takes possession now. X suddenly dies. And now Y and Z run to the city hall, no? To have their respective rights registered. This was denied by the Register of Deeds kasi it's two people at once asking for registration of their rights. Okay, so the Register of Deeds just said, go file a case in court, no? So now, who is entitled to the better of rights since there is no registration? Is it Y or Z? Okay, it's Y. Y has the better right because remember, the rule in case there is no registration of the sale is the first to take possession in good faith. Okay? Remember, Z took actual possession, right? But also remember that Y took first possession even if X remained in possession, no? Y took possession because the sale was through a public instrument. And remember that execution of a public instrument is equivalent to delivery because it is a mode of symbolic delivery. So therefore, there was already delivery to Y and he is the first possessor in good faith, better entitled to the property. Okay? Now, what if X enters into a contract to sell land to Y and subsequently X enters into an absolute sale with Z? Then Z will have the better right. Okay? Why? Because a contract to sell is not a valid sale yet. Okay? There has to be compliance with the suspensive condition, which is usually full payment. No? Please just watch my episode on contracts to sell. No? And does Y have remedy? Yes, he can still go after X for damages for unlawfully withdrawing or not respecting the contract to sell. Okay? Last example, X sold land to Y and A, okay, another person, A, pretends to be the owner and sells the same land to Z. Who has the better right? Is it Y or Z? Of course, it's Y. Y has the better right. Why? Because first, A passed nothing to Z. He's not the owner. He has nothing to pass. And second, the sale is not by the same seller. So we do not apply 1544. Okay? So I hope you may have picked up a thing or two. And that's it for my discussion on double sales. I'll go to conditions and warranties on the next episode and wrap up the other obligations of the seller by the next episode. Okay? See you soon. Bye.